I'm Greg Coffey of Friedman Law Offices in Lincoln, Nebraska, and thanks for visiting our blog. Among the frequently asked questions we get from callers with workers' compensation claims is whether it makes a difference to their case if either they or their employer was at fault in causing the work-related accident. The short answer is no. The workers' compensation system was originally intended to provide coverage to people who get hurt on the job regardless of who's at fault. This places the burden for workplace safety on the party in the best position to provide for workplace safety, which is the employer. Therefore, unless you were intoxicated or willfully and deliberately negligent in causing your own injuries, you're entitled to recover them without having to prove that your employer did anything wrong. By the same token, though, if you're injured on the job and your employer is at fault, the injury is still covered by workers' compensation, and you'd be entitled to the same benefits whether the employer did anything wrong or not. This means you don't get to recover increased damages if it turns out your employer was at fault, even if the fault was significant. This is called the exclusive remedy provision of the Workers' Compensation Act. Work comp is your exclusive remedy, the only way to recover against your employer for injuries that happen while you're at work doing your job. The exclusive remedy provision of workers' compensation doesn't prevent you from bringing a claim against a negligent third party, for example, if you're a delivery driver and get hit by somebody who runs a red light. But with respect to the employer, if the injury happens while you're at work doing your job, you can sue your employer for work comp benefits, but you can't sue them for negligence. Some people ask about OSHA violations. If the employer was somehow negligent and violated OSHA rules and caused your injuries, can you sue them for that? Well, OSHA is a regulatory agency, and it can investigate industrial accidents and levy fines for OSHA violations, but those fines are paid to the federal government and not to the person who got hurt. The bottom line is that it benefits the employee not to have to prove that the employer did anything wrong, and that they can still recover benefits without having to prove that the employer was negligent. If you have any questions, please feel free to call Friedman Law Offices at 800-876-1093. There's never a charge to find out if we can help you. And feel free to leave a comment here on our blog and hit the share button if you know someone who might benefit from the information. Thanks for logging in.